The Greater Dayton Volunteer Lawyers Project presents
Eviction.
This video is solely for informational purposes. The information contained in this video is general and should not be applied to specific legal problems without first consulting an attorney.
My landlord gave me a 3-day notice of eviction, and I've also been given eviction papers by the court. What do I need to do?
Well, first you're going to need to read the papers to find out when you need to go to court. They'll tell you where to go and when you need to be there. The papers will also tell you what the landlord is saying you owe, like for rent.
What if I don't agree with what the landlord says I owe?
If you don't agree with what the landlord is saying you owe them, you'll need to tell the court that. You have 28 days from the date when you get the eviction papers to let the court know you disagree with the amount of the landlord's claiming that you owe. The eviction papers will give you the instructions on how to let the court know that you disagree with the amount that's owed.
So what happens if I don't show up in court on the day that I'm supposed to be there?
Well, if you don't go to court, the landlord's going to win.
Okay, so if I do go to court, what do I need to do?
Make sure that you're there on time, and parking is a real problem in downtown Dayton, so get there at least 20 minutes early. Some of the courts have a dress code, so dress like you're going to a job interview or to church. Try not to bring any little kids with you, since the judge could ask you to take them out into the hall, especially if they become loud and disruptive. Also, if you have any paperwork that might help your case, you need to bring that with you and bring copies, and be organized when you come to the court.
How long will I be there?
If there are a lot of people in the court that day, it could take quite a while, sometimes all morning before they call your case, so just be patient and plan to be there a while. Once they call your case, the judge will ask you if you're behind on your rent, or if you're being evicted for some other reason. The judge will ask whether what the landlord is saying is true. After that, the judge will ask you if you have any legal defense to the eviction.
Oh, I have a defense. I told my landlord about the mold in the leaking ceiling for weeks, and he still hasn't fixed it. I've been having a hard time breathing, and so has my son. I'm not going to pay rent if he's not going to fix the problems after I told him several times.
And that's really horrible, but unfortunately the judge won't take that as a legal defense. If you have questions about what would be a legal defense in your particular situation, you should talk with a lawyer. But usually there are only a few legal defenses to an eviction if you haven't paid your rent.
Like what?
Well, the first would be if you put your rent into escrow, and that's in those situations like you were talking about if you have conditions problems. That means that instead of paying money to your landlord every month, you would be paying it to the court, which would put the money in an account and hold it for you. This is what you do if the landlord hasn't been making the repairs. That way you're still paying your rent, so you can't be evicted, but the landlord doesn't get the money until he makes the repairs.
Can I put my rent in escrow now?
Well, now that you're behind in rent, no. After the eviction notice, it's too late typically to go back into court and escrow your rent. You need to do that before your rent becomes late.
Since I can't put my money in escrow now, what are my other legal defenses?
Well, another legal defense would be if the person who's trying to evict you isn't really the owner of the property.
How do I know if they're the owner of the property?
Well, that information is public record. You can go online and do a search of the Montgomery County Auditor's website, which is at www.mcrealestate.org. Then look up the property where you live. The court will also have looked up the same information, so they should know who the owner is when you go into court.
Are there any other legal defenses?
Well, a common legal defense would be that you actually did pay your rent on time. If you did, you're going to need to have receipts that you actually did that, check stubs, bank statements, whatever proof you have that you actually paid the rent on time, take it into court with you. And it could also be with a witness that actually witnessed you paying rent. Make sure you have copies of those papers before you go into court so that you can keep the originals and give the court the copies.
I can't use any of those defenses. What's going to happen when I go into court?
Well, if you don't have any legal defense, the judge is probably going to rule in favor of the landlord, and the judge will say something like restitution granted to the plaintiff, second cause continued. That means that the landlord gets the property back and you have to move out. It also means that the money the landlord says you owe, that's the second cause the judge mentioned, is going to be decided at a later time. The court will send you papers letting you know when that court date is.
Do I have any other options?
Well, if you can't use any of the defenses I already mentioned, you've got two other options. First, you can talk to an attorney and see if there is any other defenses available, or second, you can try to go through mediation.
Mediation? What's that?
Mediation is a way for you to, mediation is a way for you and the landlord to talk about the situation and try to come to an agreement. You try to schedule a mediation before the court hearing, or there will be a mediator at the hearing, and maybe you can talk to the landlord at the trial with the mediator. The landlord and you are going to have to agree to try mediation, though. If the landlord doesn't want to do the mediation, then you're just going to have to go and appear at the court.
How do I schedule a mediation?
The Dayton Mediation Center is wonderful, and they do mediations for the eviction hearings here in Dayton. Their website is www.daytonmediationcenter.org. If you and your landlord agree to try mediation before you go to court, and there isn't enough time for you to get together before the court date, you can ask the court for a continuance. This is basically an extension of time so that you can schedule your mediation. If you and the landlord are able to settle things through mediation, the eviction case can then be dismissed.
If my landlord doesn't want to mediate, what do I do then?
Well, then you're kind of stuck. You're really going to have to either talk to an attorney and see if you have any other defenses, or you're going to have to go to a court and just show up and see if you're going to be evicted.
Okay, anything else?
Just remember, if you don't have a legal defense, the judge is probably going to rule in favor of the landlord. Don't be surprised if the judge cuts you off when you try to tell your side of the story. They're not trying to be rude. There's just nothing the judge can really do for you if you don't have a legal defense.
If you are located in or near Dayton, Ohio, and require legal services but are unable to afford an attorney, please call the Legal Aid Line at 1-888-534-1432. If you do not qualify for legal aid, please call the Dayton Bar Association Lawyer Referral Service at area code 937-222-6102. The attorney for this video was Randall J. Smith, Esquire, of Miami Valley Fair Housing Center. The client for this video was Elizabeth Reed, a law student at the University of Dayton School of Law. Script written by Elizabeth Reed.